accountable to the public, and accountable to the government. Because if the information that becomes available is used irresponsibly, and this has happened in India, if it's used irresponsibly, then it can serve to weaken the whole concept of right to information, not strengthen it. And this has been happening, as I said, this happened in India, but by taking parts out, the question has been raised that can this act be misused? And this is a widely held argument in India. People say it is being misused, some people say it can't be misused. After all, if you've got information, if you've given that information, how is the misuse if that is disclosed? But I've come to the conclusion that it can be misused. And it has been misused. How? If you've given the whole information, and the media draws out only a certain portion of that information to quote out of context in order to weaken a government argument, and then the government is not fast enough in actually responding to that, then it serves a wicked purpose, which is to weaken the government. And therefore, there has to be an exercise of responsibility by the media. This has not always been so, and we have been talking about this with the media inside India as to how all sections of society must realize that it is a responsibility that falls on all of them. So, what is the strategy for success? The strategy for success is to put out as much information as possible under the law, which is there under Section 4, and I will describe to you Section 4 a little later. But it restructures, this law has restructured the debate from what the government can give. Earlier, when I was undergoing my training as a young IAS officer, was told that that you have a lot of information, it's your responsibility, do not give it unless you are compelled to give it. Now, if you have information, and the law does not ask you not to give it, you must give it. That is the difference. And then there it sets up a Central Information Commission, which has this kind of power to decide on what should and what should not be given. But what is the obligation of every government organization? These are the obligations. This law is perhaps the first law of India, it was the first law, I think it's perhaps the only law, which actually capitalizes on one of India's greatest strengths. And I would characterize that as India's greatest strength in software technology, whereby it has been given the facility to store and disclose information of a huge quantity in a relatively small area. Our own record rooms are oozing, and it is very difficult often to find information. I've experienced that myself while working even in the Prime Minister's office, where one had to go and find the concerned person who happened to be dealing with that subject to actually get the file out which one wanted to see. Now it should be possible to access it much more easily, and the law lays down that it should be done. But it has not been done. I must admit that this has not happened. What was required was the structure of keeping records in government required to be revised. There has been the case that information now being generated has been generated in such a manner that can be stored and made accessible. But this talks of all records being made accessible. And all records have not been made accessible. We do know, for example, that persons have been asking for information regarding the death of Subhash Chandra Bose, because there have been a lot of Bengalis who feel that in fact he did not die in the accident, in that air crash. He lived and was actually assassinated thereafter and actually lived in the Gulag. And there is such information apparently in the government, but the government was denying this information. When we actually heard the case before the Chief Information Commissioner, what we discovered from the department was the government had no intention of trying to conceal the information. They just couldn't find it. It was supposed to be there, but they were not being able to find it. So this This actually seeks to deal with that particular issue. Then, the question is, what is a public authority? This again goes well beyond anything that is in the government alone. And here is where political parties have also been included. The one that I've highlighted at the end. Any body owned, controlled, or substantially financed, or any non-government organization substantially financed directly or even indirectly by funds provided by the appropriate government. The principle being the same, which I described to you earlier, that anybody who uses public funds is answerable to the public. But this is a subject which, as I said, has not yet been finally defined, even by our own law, because certain organizations, the government has, the Supreme Court has held them to be public authorities, even though they've been set up by the private sector, but they availed of government services. There are those which were earlier government departments which have been privatized, but because they were set up by government law, they have been deemed to be public authorities, and this is a huge variety. But here you have public authorities, a question is under discussion and dispute even inside India at present, despite 8 years of access. But organizations like the Commonwealth Games Committee, these are not organizations set up by government, they're private organizations, but the financing is so huge that the Commission declared them to be public authorities, a matter which has been upheld by the Supreme Court. And now you would have heard, of course, that during the last Commonwealth Games, a lot of things which should not have happened did happen and did get disclosed because of the fact that the Commonwealth Games Committee actually comes under the Right to Information Law. This is exactly an organization of this nature. There is an overview. Next, there is an overview by the Commission. It has there's legal provision for the Commission to ask. It is supposed to monitor and implement the implementation of the law. It can ask organizations to disclose information which they would otherwise not disclose, if it feels that this is the best interest of government. But then, what is the right to information? The next point. The right to information, this is interesting. This discloses to you that a right to information only is a right to access records which are already existing. You cannot ask for records which do not exist. And therefore, the apprehension, and I've been trying to explain this to our political parties in India, who've been saying that, well, we now have to create information to give if we have been declared public authority. I've been trying to explain to them that you do not have to create anything. It's only information which you have. Your records. You see, in the definition of information which I've given to you earlier, it says that information means any material in any form. And here, the right to information only is the right to actually inspect the records. What is actually in position, in material shape. If you want to know what went into the building of the road, you can get a sample of the material used in the road. You can get that tested, and people have done that. People have done that to their benefits. And in the slums of Delhi particularly, it has worked extremely well. Because in the slums of Delhi, they will be built every year, huge amounts of money would be spent, and every monsoon they'll be washed away very conveniently, so that by the time the next monsoon was to come, another road would be ready, be again washed away. But the local slum dwellers, slum dwellers became conscious of this and started asking, now we want to know what are the material used in these roads. And that's what I mean by public responsibility. What do you ask for? And the NGO's responsibility there came in because the slum dwellers, poor things, were not really very literate. And the NGOs were able to tell them, this is how you do it, this is how you get this information. And so that information was disclosed. And you get certified copies, and you material, as I said, you obtain information and samples of material. You can get this under India's right to information law. So, the process next describes to you how you process, how you go through the process. The application is supposed to be given in writing or electronically with a prescribed fee. the public information officer expected to be appointed in each department. The public information officer is expected to help, assist the person, the member of the public. This again is something that does happen, but rarely, not usually. And it's supposed to be provided with a specific date and time period. This is again not really being adhered to. And there is no fee for a delayed response. If the government does not give the response within a specific amount of time, then the government is not supposed to charge a fee. Now I come to the point of what is not open to disclosure. The first thing, and you would all agree this should be the case in every such organization, in every such law, information disclosure which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, and relation with any foreign state or lead to incitement of any offense. An interesting piece of information with regard to relation to any foreign state, with which you will relate, of course, is the question of the Jinnah House in Mumbai, which the Embassy of India had been, the High Commission of Pakistan had been wanting to have as its consulate in Mumbai. And there's a whole dispute as to who is the actual owner of that property and whether that property could be taken over by the High Commission. The External Affairs Ministry argued that this concerned the relationship with the foreign state, since Mr. Muhammad Ali Jinnah was Qaid-e-Azam, the father of Pakistan, and therefore it would any information in this regard would therefore prejudice that information. Therefore, we had to hold that the information cannot be given out. It was asked for by his grandson, Mr. Nasri Wadia. But this is one thing, but also economic interests of the state. This is not something that can be disclosed. And in this falls things like you see the presentation of the budget. Because on the day, just after I'd taken over, the first call I got from the finance secretary was I was presenting my budget, and before I presented my budget, I got a whole lot of requests under the right to information. What do I do? So I cited this clause. That under the right to information law, anything that goes against the economic interest of the state, you do not have to disclose. So you can imagine this is very wide. It's a very wide area of non-disclosure. And under this, you see, the army, for example, when the law was first passed, the army had objection. The army comes under this law, the Indian army. The Indian army had raised objections. They sent a whole delegation to talk to when the government had rejected their objections. Then they came and had sent a huge delegation of senior army officers to talk to me and people from the Ministry of Defense, saying that this would compromise defense. Now the Indian army today has the best form of information disclosure of any department in the government of India. Because they do not have to disclose anything which concerns their security, their national security. And who decides what is national security? Obviously the army. Nobody else is going to tell them that, no, I can't sit as Chief Information Commissioner and say, well, I'm the son of a general, therefore I say that this does not compromise national security. I can't do that. So it's only the army which decides that, with the result, the applications that go before the army, which are very smoothly dealt with, because the army is high on discipline, are applications which concern really the promotions of people, or injustice done to any individual working in the army, or preference given to some person or the other, things like that, which the army itself would like to keep under control, would like to know about if it's happening. So in that way, it greatly strengthens the army. So this is that clause. But then there are a whole lot of others. Information which has been expressly forbidden or to be published by any court. Next. Information, the discharge of which would cause a breach of privilege of Parliament. And information including commercial secrets. Again, we've told the political parties that any information which will impede your competitive strength is information which does not have to be given, that is excluded under the law. And information available to a person in his fiduciary capacity, That means a lawyer-client relationship, a doctor-patient relationship, and our courts have now gone to a great extent, thanks to this law, to actually define a fiduciary relationship very, very closely. Information received in confidence from a foreign government, I already told you about that. Next, information should impede the process of investigation or apprehension or prosecution of offenders. Now this is interesting. It does not mean our police was sort of keeping all kinds of information confidential, even the FIR, the First Information Report. Now under this, the FIR cannot be kept confidential. The FIR has to be disclosed. It's a public document. It's only information which should impede the process of investigation or registry of investigation or apprehension or prosecution of an offender. So it is therefore limited, and therefore it has helped make the police much more accountable. I suppose in your country as in ours, the police can do with a little more accountability, because very often our police is accused of having acted in a manner that was not in the best interest of the person who they were expected to be serving, of the public. Then, cabinet papers. Now you will understand cabinet papers, these are not to be disclosed. Then information which relates to personal information. Now this is again very interesting. Personal information, private information. India has no laws protecting privacy. But you will understand that a principle of democracy, a basic principle of democracy, is respecting the privacy of the individual. So here you have the right to privacy, you have the right to information. How to marry the two? We, in our decisions in the Central Information Commissioner, relied heavily on the British law, the Data Protection Act of 1998, and the US law of torts on the question of what constitutes privacy. And I have been urging the government to come up with a law on privacy, because now, with the right to information having become a right so widely used, it has also become necessary to define what is a right to privacy. But then, you see, what it also says is, notwithstanding any of these exemptions or the Official Secrets Act 1923, a public authority will allow access to information if public interest in disclosure outweighs the harm to be protected interest. So now the public interest is paramount. And that is what I meant when I started off by saying that in a democracy it is the public interest which must come before peace. Not political interest, not individual interest, not vested interest, not even corporate interest, but the public interest. Now, this information is all disclosable after 20 years, but it's still not disclosable if it concerns the first item, which was information disclosure which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, or relation with any foreign state. This will still not be disclosable. Then also, cabinet papers are disclosable once the exercise is complete. Once the exercise agreed upon has been completed, that means if a law is passed, which is the law that the cabinet had decided upon, at that stage, the cabinet papers can also be disclosed. So you can actually examine what went into the making of that law. But till such time as that law was not passed, then the cabinet papers could not be disclosed. This also proved somewhat useful, because sometimes the government has tried to come up with amendments, and then without dropping the amendments, because there's been a public outcry, has said we will not come up with the amendments, but has not actually dropped the amendments. But on using the RTI, it has been able to find out, it's been possible to find out that the amendments have not yet been dropped. And therefore, the government could then be pressed that, look, if you want to satisfy the public, you must drop these amendments.